start. In each of these cases, challenge is to the bail granted to the respondent by the Bombay High Court Nagpur bench. Stop. Since all these appeals have a common matrix, stop. They are taken up together. Stop. On the basis of allegations that the respondents were guilty of having committed cheating, preparing forged and false documents for the purpose of cheating, using the said documents as genuine abatement of crime, committing criminal breach of trust by forming criminal conspiracy. Stop. In furtherance of their common intention, law was set into motion. Stop para. They were convicted by the trial court and have preferred appeals before the High Court and had prayed for grant of bail by suspension of sentence in terms of Section 389 of the Code of Criminal Procedure 1973. Stop. The High Court primarily granted bail to each of the respondents on the ground that bail was granted during trial and the liberty was not misused. Stop. Further, ground indicated was that there was likelihood of delay in disposal of the appeals. Stop. In the case of respondent, it was stated that the evidence appeared to be scanty against him. Stop para. Questioning correctness of the order passed in each case. Learned counsel for the state submitted that there was large scale of manipulation of records resulting in manipulation of results of the candidates, and each of the respondents had a definite role to play. Stop. Apart from the cases where they have been convicted, a large number of connected cases are also pending. Stop. In the case of respondent Madhukar, two cases under the Prevention of Corruption Act 1988 were pending. Stop. In one case, the said accused had offered bribe to the investigating officer and was caught red-handed. Stop. It was submitted that considering the gravity of the offence, the sentences were directed to run consecutively in terms of Section 31 bracket 1 of Code. Stop. It was stated that the High Court was misled in the case of respondent Janki, who made a false statement before the High Court that he had deposited fine amount while in fact he had not done so, as would be apparent from the second order. Stop. It was essentially submitted that without indicating any plausible reason contemplated under Section 389 of the Code, the bail has been granted. Stop. The seriousness of the allegations for which the accused respondents have been already convicted has been completely lost sight of. Stop para. Learned counsel for the respondents, on the other hand, submitted that the parameters for grant of bail and cancellation of bail are different. Stop. It was submitted that some of them are very elderly persons and have retired from services. Stop. It is not a case where any irrelevant factor has been taken into consideration. Stop. it is pointed out on behalf of respondent Madhukar that the said accused is stated to have centers round two chits which were exhibited. Stop. They did not in any way establish the involvement of the accused in the alleged crime. Stop. That is why, in his case, the High Court observed that the evidence is scanty. Stop. Overall,